Hello friends, in the series on the income tax cases, today we will discuss a very important case of Honorable Bombay High Court in the case of Siemens Financial Services Private Limited versus Deputy Commissioner of Income Tax. This case has been reported in 457 at page number 647 and the matter has been decided by 25th August 2023. In this case, section 148 notice was issued to the assessee for the assessment year 16-17 on 25th June 2021. This notice was in the old format, and as all we know that the Supreme Court has given relief to the department for all those notices which have been issued by the department between the time period 1st April 2021 to 30th June 2021 in the old format, and which were covered by the 2020 Act. In all those cases, the notices under section 148 were to be considered show cause notice in section 148A clause B. So, by taking the shelter of Ashish Agarwal case, in this case, the department issued notice under section 148A clause B to the assessee on 31st May 2022. Basically, we can say that the notice which was earlier issued by the department on 25th June 2021 was allied by the Supreme Court judgment of the Ashish Agarwal, and so the department issued the notice under section 148A clause B on 31st May 2022. The assessee submitted its objections, replies, and after taking into consideration those replies, the department issued the order under section 148A clause D and notice under section 148 on 31st July 2022. Up to this point, there was no problem. But when the department issued the notice under section 148, the department took the approval of the Principal Commissioner of Income Tax in spite of Principal Chief Commissioner of Income Tax. If we read section 151 clause II, that says that if the department has to issue the notice beyond 3 years, then the department has to take the permission of the Principal Chief Commissioner of Income Tax. The assessee went into the writ court by having his point that this notice is invalid because for issuing this notice, because this is related to the assessment year 16-17, 3 years were expiring on 31st March 2020 and the notice has been issued on 31st July 2022. So, for issuing this notice, the department has to take the permission of the PCCIT in spite of PCIT. The Bombay High Court said that in this case, the point of the assessee is correct and the approval under section 151 clause II should have been taken by the department and quashed the notice. It was the plea of the department that the time period of issuing the notices has been extended by the TOLA provisions. So on this point, the point of the Bombay High Court was that the TOLA was applicable only for extending the time limit for issuing the notice, and TOLA was not for regarding that you can take the permission of an authority which is not justified for that. So section 151 clause II provisions are not affected by TOLA, and once the period of 3 years is crossed, even if this notice is within the time limits according to the TOLA provision or the extended time period, but if the permission is not taken according to section 151, then in that case the notice will be invalid. Friends, this case is very important because in many cases the department has made again the mistake by not taking the permission of the Principal Chief Commissioner of Income Tax when this case is related to the period which is beyond 3 years. So friends, in this case the Bombay High Court quashed the notice under section 148 and the assessee got a very big relief. This is a very awkward situation for the department because earlier the Supreme Court has given a great relief to the department by levying the 9,000 notices, but this time it seems to be very difficult that when the department again will go to the Supreme Court, then I think that the department will not have any grounds to justify its point. at the end of this video. Once again, I am repeating the name of the case. The name of the case is Siemens Financial Services Private Limited versus Deputy Commissioner of Income Tax, and this case has been reported in 457 ITR at page number 647, and the matter has been decided by Bombay High Court, and the date of the judgment is 25th August 2023. Thank you, friends.